Tell me, Nick. So I've had a couple of really, really weird experiences with mixed use properties. So, I mean, we forget zoning to begin with, because I mean, we all know what zoning says versus how people actually utilize properties are
Yes.
two completely different worlds.
Yeah.
And some of the experiences, for instance, we had to do evictions on places where the people weren't related. So there was a specific business running from one room that had a window to the outside, but then there was a residence in that room, and you basically had to clear out the whole house. But now you had to institute multiple evictions in multiple different ways and fashions to actually try and achieve the different results. And the worst part being that some of the places people still kind of went through and they were mixed up. So it became very difficult to clear those places, because you were never sure whether the owner also happened to sleep underneath the table or desk. Any experiences from your side when it comes to that sort of eviction?
Absolutely. And unfortunately, in our firm, we keep our residential and our commercial sections separate.
Not on this one.
I actually gave away a commercial instruction about a week ago, which had the same problem. Similar property, but you'll remember the old school way of doing properties. If you look at your central Cape Towns, your central Pretorias, where there was a commercial use property on the bottom and a residential use property on top. And in some of those circumstances, you'll note, if you look at the particular way that those properties are registered, they're not actually distinct. So it's the use is intended commercial at the bottom, residential at the top, obviously with the idea that the owner stays up top. And I often get situations like that. And in those circumstances, like I've said before, unfortunately, if you can't really distinguish those two particular properties, it's always just safer going for a circumstance where you do the residential eviction, and you basically ask for an eviction for both sections. Okay. Again, if you want a commercial eviction, it's very similar to a residential eviction, as you say, in the sense that you do need to show that the right of occupation that the tenant had in the particular premises has been cancelled or terminated, depending on the particular circumstances. So that's really the crux for your commercial eviction. You need to show that that right has been cancelled or terminated. You don't then need to make the additional averments that PI requires, but that needs to be established. So if you do a residential eviction, you're going to cover your base for your commercial eviction in any event. And so again, in circumstances like that, it is nightmarish where you've got a mixed use and you've got different people. Safety first, go for the residential eviction in the circumstances. If you can clearly distinguish them, you can do a commercial eviction. And as you say, commercial eviction, we are privileged in that it's a little bit quicker, a little bit easier, because at the end of the day, when you get to court, what the court is going to do in a commercial eviction is simply apply the agreement that's between the parties. And if the right of occupation has been terminated or cancelled in the circumstances, the court is simply going to say, but there is no right to continue occupation, and the eviction will be granted. They don't go into the provisions that PI requires, obviously looking at elderly, constitutional rights, stuff like that. Commercials, pretty clear cut. Is there a right? Is there not? And the court will apply from there.
Yeah, absolutely. So I've just thought of 3 scenarios, so I'm just going to throw it out there.
Sure.
Interesting one. So in my experience, in both departments, commercial and residential, I think it's only been once or twice I've actually experienced a situation where a property happens to be hijacked, but people are using it for commercial reasons, not necessarily to live. And by hijacked, I mean, it's very loosely. So it's not like they went and set up a shack, but what you find is they happen to be there for some reason or another, whether it was through a previous employer or whatever the case was, and they just continue to trade. There was never any agreement with the owner. No one ever asked any questions until you find out this person's there, and they've hijacked the property. So they're completely unlawfully, never had any consent to be there, never had any lease agreements and that sort of thing. Yeah, so obviously my experience there is to say, well, you never had consent, so you need to get out. You're there unlawfully. Yeah, any interesting stories from your side with
so actually you and I were discussing a little bit before we went live about Central Joburg, and I've had a couple of experiences with some Central Joburg properties, same thing that you're talking about. So if we have businesses that, in fact, what happens is the business gets sold from one person to another person, and the notification is never sent through to the landlord. Now, you will see that in your lease agreements, most lease agreements are going to have a clause that says you can't change ownership, you can't change shareholding without notifying the landlord. And the obvious reason for that is you don't want someone, as a landlord, you don't want someone in the premises that you don't know who they are. But it does happen on occasion where, for instance, a business just gets sold to another individual entirely. Now, depending on the particular circumstances, if you've got a juristic entity, remember your juristic entities survive beyond the particular individual that might be running the company. Okay, if it's been sold properly, and often these things are not sold properly, they're just handed over to another particular person. But that juristic entity that's in the property itself remains the juristic entity. So you're looking at doing the eviction on that particular individual. The other circumstances, obviously, if it's handed over from one person to another person, there's a completely different person in occupation of the property. Okay, again, like you say, there's no real consent to be there. Okay, so there's no real right of occupation there. In particular, the landlord obviously doesn't know who the tenant is. And remember, material term of conclusion of a lease agreement is obviously, well, the material term is a meeting of the minds between the parties. And, the landlord can't give a lease agreement to someone who they don't know they're contracting with. So that would preclude any sort of right of occupation in the premises in any event.
Absolutely. It kind of leads into like another topic. So Cilna and I often discuss implications of an employment contract. So a situation where, for instance, you have a caretaker in a building, and this caretaker, gets occupation by virtue of his job, his employment. You have the same thing when it comes to security guards and stuff like that. On commercial properties, again, just once or twice, it's few and far between, but I've experienced situations where your tenant, as a commercial tenant, has somehow put one of his staff members on the property in order to stay there, be it, again, security, landlord, or just a laborer that sleeps on the property, and now conducting the eviction. I suppose it goes back to our previous topic where we said, what do you do if it's mixed?
Sure.
But yeah, it is a good example of a situation where unintentionally or incidentally, an eviction goes from commercial to residential.
Yeah, and it's super important. I know, when it comes to residentials and commercials as well, make sure that your attorneys are asking for an appropriate order from the court in the circumstances. What's fundamentally important in circumstances like that is that an order is asked for where the eviction is granted against whoever the primary tenant is. So you've got a lease agreement, you've got a commercial entity in there, and an order is also made for eviction of anyone who has occupied the premises by, through, or under them. And that's fundamental. You don't want to get to a circumstance where your eviction's being granted. You can evict the company, okay, but they have put a security guard or some other level of employee in the premises, and your eviction order doesn't cover that person specifically. That can be an absolute nightmare. You got to make sure that anyone who occupies the premises by, through, or under them is also ejected from the particular premises. And that also leads on to, sublessees in the circumstances. So another circumstance which we do experience every now and then on your commercial sector is where an entity who has leased a commercial premises for use, sublets the property over to someone else who is going to use the property also for commercial purposes. Now, of course, the rules when it comes to subletting are quite clear. You as the landlord actually don't have any contractual relationship with the sublessee in any way. So when you do your eviction, you don't bring the eviction against the sublessee that is currently in the premises. Your eviction is against the lessee who you entered into the primary lease agreement with. And then again, you include anyone who that lessee may have placed in the premises by, through, or under them.
So out of interest, just to kind of like complicate things a bit like I normally do, a commercial tenant sublets to a residential person, even if it is an employee, but they actually sign a lease agreement and go, great, you can stay here, you can reside here. You as a landlord enter into a commercial lease, no nexus between you and that final tenant, but that final tenant's based there on a completely different application of the law versus who your tenant is, which is based on commercial.
Sure. Yeah. I'm still going to defer to Pi. So Pi is pretty clear. Someone's using that as a temporary or a permanent residence, you've got to follow the provisions of Pi. Again, it would be very scary to get to court at the end of the day. Ultimately, you've brought a commercial eviction, even though I agree your particular tenant was a commercial entity, it was for a commercial purpose, and they're not, in fact, in the property. The fact is someone is in that property and using it for a residential purpose. And of course, legislation will always override your contractual agreement in the circumstances. So you can't circumvent the legislation, even if your contract says, well, this is a commercial purpose. Is someone living in there? You've got to follow Pi.
Yeah, absolutely. And I mean, so the interesting thing with Pi, because we speak about nexus and saying that we've got the agreement with the commercial tenant, so we bring the application against them. But I think the point we're also driving home is, so that final person on the property still needs to be considered. And when we're dealing with residential, Pi would apply. So yes, it's a sublease and whatever the case is, but to a certain degree, people, that doesn't, as far as Pi is concerned, they're worried about the person on the property. So you'd still have to take those extra steps to go knock on that door and say, who are you? What is your name? And what are your circumstances? Because that's what Pi requires. Pi wants to know, will you be rendered homeless? Are you an elderly person, a household headed by a woman, whatever the case might be. And because it's residential, all of a sudden it becomes imperative that, forget the lease for a second, we're also dealing with an individual and Pi applies to that individual. You're just going to need your attorney to basically plead around that and go, look, there's a commercial, so here's the lease, but then this happened and this person's there. So ultimately I need an eviction against them and them. This one based on contract and this one just because they happen to be there and they shouldn't be there.
Yeah, 100%. And unfortunately, we do have a tentative relationship with Pi, but it's important, as you said, the idea at the end of the day is the court needs to consider the rights of the people that are in there, and especially in a sublease situation like that. Remember, if the eviction that you're bringing is against the tenant for whatever reason, they've either not vacated, they're not paying you rent, whatever the case is. And especially in a circumstance where there's a sublessee, the sublessee might not be the person at the end of the day who is in fact done any wrong in the circumstances. They might be paying their rent directly to the tenant as they should be. But their rights do need to be considered in the circumstances.
Absolutely.